In our previous video, already we have discussed regarding the very meaning, definition, and the philosophical or theoretical evolution of human rights and its practical evolution and development that already we have finished in three previous videos, and in this particular video we would like to discuss human rights and its very position regarding Indian constitution, and in relation to that the important parts of Indian constitution, that is part 3, which consists the fundamental rights, and part 4, which consists the directive principle of state policy, that are very relevant in this context. So also we'll discuss regarding the Covenant on Civil and Political Rights of 1966, so also the Convention on Status of Refugees of 1951, and the very Protocol on Refugees 1967, in relating to the position of human rights as per constitutional provisions of India. So the Indian constitution was adopted in 1949, just 1 year after the Universal Declaration of Human Rights by the General Assembly of United Nations Organization in 1948. India was a signatory to the declaration. India has also ratified the international covenants on civil and political rights, and also the social, economic, and cultural rights of 1966. While most of the rights in the declaration and the civil and political rights covenant found place in Part 3 of the Indian Constitution, the social, economic, and cultural rights covenant of 1966 found their place in Part 4 of the Constitution of India, which consists the directive principles of state policy. While the fundamental rights are enforceable, the directive principles of state policy are not enforceable. The similarity of the provisions between the Constitution of India and the Declaration and the covenants are as follows: the fundamental rights placed under Part 3 from Article 14 to Article 35 are the true reflection of the human rights found in the Universal Declaration of Human Rights of 1948. The founding fathers of the Constitution, before enactment of the Universal Declaration of 1948, that gave due importance to these provisions before the enactment of Universal Declaration. After ratifying the Covenant on Civil and Political Rights in 1979, India has established on the international plane its consent to be bound by them. It has an obligation to provide to the individuals the rights contained in the covenant, leaving aside Article 17, 18, and 24 of the Constitution. And Article 14 to Article 25 in the Constitution covers all the provisions of human rights provided in the International Covenant on Civil and Political Rights. The directive principles in Part 4 of the Constitution depict the ambitions and aspirations of the framers of the Constitution regarding the welfare state in India based on social, political, and economic justice. Article 39, 41, 42, 43, and 45 and 47 of Part 4 of the Constitution consist almost all the human rights provided in the International Covenant on Economic, Social, and Cultural Rights of 1966. India has ratified the covenants in 1979 and has the obligation to provide to the individuals the rights contained in the covenant. Besides adoption and incorporation of the provisions of Universal Declaration and the covenants, India has become a party to a number of human rights conventions. As regarding that Article 34 of the Vienna Convention, which says that a treaty does not create either obligation or rights for a third state without its consent. So, in other words, rights and obligations arising from a treaty are binding on India, even without a party to the convention relating to status of refugees of 1951 and its protocol of 1967. It has provided shelter to thousands of refugees from Tibet, Afghanistan, Sri Lanka, and Bangladesh. Article 14, 20, 21, and 22 of the Indian Constitution protect some of the rights of refugees. So, accordingly, the Supreme Court now will discuss regarding one important leading case in relation to refugees. National Human Rights Commission versus State of Arunachal Pradesh in 1996. Our Supreme Court in this leading case and in another important leading case that also relating to state of Arunachal Pradesh versus Khudiram Chakma in 1994, our Supreme Court gave relief to Chakma refugees. Article 51 of the Constitution states that India shall foster respect for international law and treaty obligations in the dealings of organized peoples with one another. No doubt it is not enforceable before any court, but the constitutional policy is committed to foster respect for treaty obligations and to apply the principles in making laws. India has shown to the world community that it has faith in the promotion and protection of human rights by becoming a party to a number of conventions. The notification to a number of conventions signifies the ratification to a number of conventions signifies that it intends to be in the forefront of the worldwide human rights movement, as this obliges India to honor the obligations as imposed by virtue of Article 51 of the Constitution and Article 73 of the Constitution states that the power of treaty making as an executive power of the Union government. So also, Article 253 of the Constitution provides that implementation of any treaty, agreement, or convention rests on the lawmaking power of the Union Parliament. And now we'll discuss how the entries entry 10 to 15 of list 2 of schedule 7, and that is of the Constitution, specified the areas on which the treaty making power of the Union Parliament is confined. The above provisions make it clear that treaties do not acquire the same status and force as validly enacted law. They are required to be implemented through legislation. So, in this connection, we will discuss one of the important leading cases, and that is Vishaka and others versus State of Rajasthan, and which was a case of 1997, and the Supreme Court declared that ratification of a treaty alone is not enough for the courts to enforce the provisions of the conventions. They are required to be transformed into law of the land. As long as enactments do not take place, the courts shall apply only those rights which are not inconsistent with the Indian law. So, in that connection, we'll discuss another important leading case, that is Apparel Export Promotion Council versus A.K. Chopra. And it was a case of 1999 where Supreme Court further held that in cases involving violation of human rights, the courts must forever remain alive to the international instruments and conventions and apply the same to a given case when there is no inconsistency between the international norms and the domestic law occupying the field. So, we'll discuss the very provisions of Article 330, Article 332, and Article 335, Article 338 and 340 regarding human rights and its position under Indian Constitution. So, further some other features of the Constitution to promote and protect human rights of certain deprived classes in the Indian society. So, provisions for reservation of seats for the scheduled caste and scheduled tribe in the House of People and the state legislative assemblies are provided under Article 330 and Article 332 respectively. Article 335 states that claims of scheduled caste and scheduled tribe to services and posts shall be taken into consideration. Also, establishment of a national commission for scheduled caste and scheduled tribe is provided under section 338. Appointment of backward commission to investigate the conditions of backward classes is underlined in Article 340. With reference to the above provisions, the Union Parliament enacted a number of acts, and such acts which are came into force. One is the Scheduled Caste Scheduled Tribe Prevention of Atrocities Act 1989, the Protection of Civil Rights Act 1955, the National Commission for Minorities Act 1992, the National Commission for Women Act 1990, the National Commission for Backward Classes Act 1993, and finally the Protection of Human Rights Act 1993. So now we'll go to the very conclusion that we derived from the position of human rights as per the provisions in relation to Indian Constitution. So the above analysis shows that although India Constitution contains a number of provisions of the Universal Declaration of Human Rights of 1948 and the two covenants relating to civil political rights of 1966 and the social, economic and cultural rights covenant of 1966, their realization is a dream to be materialized. In India, a large number of people are deprived of basic necessities. They are denied the minimum needs such as work, healthcare, education, and shelter unless they are adequately provided. It is an hypocrisy to talk about promoting human rights to those who have no means to have two square meals daily. Is it not illusionary to talk about human rights when such conditions are prevailing in the country? The solution for making human rights movement meaningful to a large sections of society depends upon the material conditions and restructuring of the social and economic order so that they may be able to realize the economic, social, and cultural rights as long as they are deprived of these rights. It is a paradox to think of other rights which are more sophisticated that the farmer, so the Union Parliament and Union Executive, besides the Union Judiciary, have a serious role to play in bringing implementation of the provisions underlined in Part 3 and Part 4 of the Constitution. So, our discussion relating to human rights and its position under Indian Constitution that we have just now discussed, those international covenants and conventions on status of refugees, the very protocol on refugees of 1967, and the four most important leading cases such as National Human Rights Commission versus State of Arunachal Pradesh 1996, then State of Arunachal Pradesh versus Khudiram Chakma 1994, and the third most important leading case, that is Vishaka and others versus State of Rajasthan in 1997, and the fourth important leading case, that is Apparel Export Promotion Council versus A.K. Chopra 1999, and all those important provisions of the Constitution relating to human rights and those enactments relating to human rights why the Indian Parliament and the Union government, such as the Scheduled Caste, Scheduled Tribe, Prevention of Atrocities Act 1989, the Protection of Civil Rights Act 1955, the National Commission for Minorities Act 1992, the National Commission for Women Act 1990, the National Commission for Backward Classes Act 1993, and finally, the Union Parliament legislated and enacted the most important act, that is Protection of Human Rights Act 1993. So, in our upcoming video, we will discuss the position and importance of human right in relation to the Union judiciary or the Indian judiciary. That means exactly the very role played by our apex court or the Supreme Court of India in preserving and protecting human rights in Indian context vis-a-vis to Indian Constitution.